In the heart of an industrial district, Jeremy managed a manufacturing warehouse that throbbed with productivity. The products they assembled bore someone else's name, but their reputation depended on flawless execution every single time. For Jeremy, the business was less about the hum of conveyor belts and more about risk management. He was calculative, not callous, always running the numbers in his head. 1% error rate when you ship 100,000 products in a month means 1,000 potential failures. In an era of social media outcry, a single misstep could be catastrophic. Jeremy was diligent with his insurance. Brokers, with their tailored suits and confident reassurances, convinced him that his multi-million-dollar policies were generous. Still, he knew that peace of mind wasn't a contract. Coverage could run out. It was in the fine print where Jeremy truly protected himself. For every client, whether emerging tech brand or multinational conglomerate, his attorney insisted on one line in the contract that rarely garnered attention: limitation of liability to insurance coverage. The unthinkable struck on a Tuesday. One of Jeremy's best-known clients received a product run riddled with an undetectable defect, a design glitch from their own engineers that worsened on Jeremy's lines. Within days, the client logged spiraling losses as negative reviews and recall orders poured in. Hurt, angry, and under their own pressures, the client's legal team struck hard. They summoned their best attorneys, seeking not just compensation, but a punishing, headline-making judgment. On the stand, Jeremy's engineers explained, and opposing counsel hammered away at protocols, oversight, and industry standards. In the end, the verdict was lopsided. Damages awarded to the client soared past what Jeremy had considered possible, even hypothetical. The sum was astronomical, eclipsing his insurance by a painful margin. Stories in the manufacturing world often end here. Insurance pays up to the policy's ceiling, and then, with wolves at the door, the business is bled dry. Machinery sold at auction, accounts seized, executives forced to walk away from decades of work. Jeremy prepared for the worst. But as the creditor's lawyers prepared restraining orders and asset lists, Jeremy's attorney pointed to the contract's overlooked safeguard: the ceiling section. It was a single sentence amid pages of legalese. In no event shall the manufacturer's liability exceed the total amount of insurance coverage actually paid out by its carrier. The court reviewed the clause and deliberated. As the insurance company cut its check for the claim, the judge's ruling followed. The contract's limit was valid. The client, however aggrieved, had agreed to this clause when they signed. The insurance company paid out its maximum limit, and the moment that check cleared, Jeremy's liability was legally extinguished. The excess judgment, the part that should have bankrupted Jeremy, simply vanished into thin air. The best time to negotiate the end of a lawsuit is before you even sign the client. Jeremy's foresight turned a potential business killer into a manageable insurance claim. He didn't just insure his risks, he defined them. Because he set the ceiling on his liability, the storm could only go so high before it ran out of room.